Good morning, everybody. I'm your host, the Supreme Litigant. I'd like to welcome everybody back to Smart Loc TV. Before I begin, y'all already know the routine. If you haven't already, please go ahead and hit that like button, hit that subscription button, and turn that notification bell on. I'll give y'all a few seconds to do that. All right, this will be part 2 of the video of me reading the book. I think we were on this part right here, this paragraph right here, because I had just read this up here. I stopped right here yesterday, so we're going to pick up right back here. However, there is an explosive jaw-dropping factor as it relates to the payment of support, which holds its authority in the law of contracts that every parent, I think the author meant that every parent needs to know. According to the law of contracts and case authority, a parent could create a contract with the other parent by paying the other parent a monthly amount in financial support and would be stopped, in other words, collaterally stopped from reneging on that contract, even though the parent was being deprived of the custody of their child. Oh, that's interesting. I'll translate this legal language into terms a regular layman or citizen can comprehend by a simple explanation. Say a father had been consistently asking his child's mother to allow him to spend 15 overnights with his child. But the mother consistently refused to do so without any legitimate purpose. As we have read, according to natural law, the father was relieved from the duty to support the child, and just as much as he was relieved from the duty of support, he cannot be forced by any court to pay support. However, let's say that the father decided to pay the other parent a monthly amount in child support, although being deprived of custody through no fault of his own. According to at least one Supreme Court case that we will dive into soon, the father has potentially created a contract and is now collaterally stopped from reneging on the contract. So this particular contract is based on his conduct, and probably unless he actually said that he was going to make these payments and it was mutually agreed, by the other parent. This appears to be a contract implied as opposed to a contract expressed. This is scary because millions of parents may be trapped in contracts based on a voluntary consent that they had no knowledge would result in 18 years of support to the other parent who did not deserve the award of support payments in the first place, according to natural law. Okay, this makes sense. As I will go into soon, these potential contracts may be of no concern because, one, it will be bad case law to create these precedents, and two, these alleged contracts lack the contractual capacity to form a binding contract and is further substantive unconscionable. However, it is of no concern, it shall remain to all the highest of concern. Let's take a look at a recent state Supreme Court case, and then I will reference this case with natural law. This case speaks into context on the creation of contracts based on the obligation of support and not specifically payments of support. That's interesting. See how they be playing these word games, y'all? However, I will use this Supreme Court case as a source and reference to state how a contract can be formed, forcing you to pay support to the other parent based on a possible contract created by your voluntary consent in paying support to the other parent. It is important to know that most legal cases are wrapped in quantum complex, double-speaking legalese. I agree with that. A language designed to be privy to only the most seasoned attorneys. I'm going to call them counsel. That's what I'm going to call them, because I know the distinction between an attorney and counsel. Anybody can be an attorney. That's, anybody can be an attorney, generally speaking. Um, to decode their language takes skill, patience, and a keen eye and understanding. I agree. I mention this because the GA Supreme Court case of Wright versus Newman is such a case. However, my simple explanation of this case will allow you to bypass the potential obscurity with ease and also see such obscurity in plain sight. Wright versus Newman is a Georgia Supreme Court case that held that a man named Bruce Wright created a contract where he had assumed all the obligations of fatherhood based on his conduct and actions in signing a birth certificate and giving the child, I'm guessing, and giving the child his last name, although he knew I'm guessing the child was not his biological son and was thus stopped from reneging on said contract and was liable for the discharge of the obligation. I'm going to stop right there and I'm going to elaborate on this. Do y'all know, I'm thinking, I don't know if it's HJR 19, I forgot what they call it. But anyway, when it says, Emmerich, well, you know what? I'm not going to comment on that because I don't want to take it off topic. So I'll just focus on this. But anyway, let's see, where was I? Let me see. He knew the child was not his biological son and was thus stopped from reneging on said contract and was liable for the discharge of the obligation of child support to Newman's son. Notice I say obligation of support and not payment of support. Obligation relates to contracts, y'all. I think I'm not really sure, but it seems like that's where the author is going, and that's kind of something that I was going to hint at. Contract and not payment of support. This is important, as you will soon learn. That court stated the following below. I have placed all of the relevant and material statements below for my explanation, to wit, a number of jurisdictions have recognized that a legally enforceable obligation to provide child support can be based upon parentage. Let me rephrase that. Can be based upon parentage or contract. There was no formal written contract whereby Wright agreed to support Newman's son. The evidence authorizes the finding that Wright promised both Newman and her son that he would assume all of the obligations and responsibilities of fatherhood, including that of providing support. This promise was evidenced by Wright's listing of him as the father on the child's birth certificate and giving the child his last name. See how they be playing these word games, y'all? This is why you have to really, you need to be just scared when you read case laws. Just assume that you don't know nothing until you go into a law dictionary or until you at least read the statute that is being scrutinized in that particular case. And see if they substantiate it, see if they've given a definition to what they're talking about. Because these people speak double, triple, quadruple languages. But anyway, this promise was evidenced by Wright's listing of himself as the father on the child's birth certificate and giving the child his last name. Since parents are legally obligated to support their minor children, he accepted this support obligation by acknowledging paternity. He made this commitment knowing he was not the natural father. Newman and her son relied upon Wright's promise to their detriment. Newman refrained from identifying and seeking support from the child's natural father. Had Newman not refrained from doing so, she might now have a source of financial support for the child, and the child might now have a natural father who provided emotional support as well as financial. The duty to support, which Wright voluntarily assumed 10 years ago, remains enforceable under the contract doctrine of promissory estoppel. And the trial courts order which compels Wright to discharge that obligation must be affirmed. That is an equity. Promissory estoppel is an equity. I'm not sure. It's an equity doctrine. That's what I'm trying to say. It's equity. He who seeks equity must do equity, and he who comes into equity must do so with clean hands. And there's a bunch of other ones, but that is an equity affirmative defense. If you ask me, as a matter of fact, it is an affirmative. It is an affirmative defense. It's an equity affirmative defense. So, in other words, the mother could have filed a suit in the nature of a bill in equity, which is what they call it a bill in equity, and she could have alleged these facts is what this court is talking about, and she could have argued that the defendant who she's suing is promissory estopped from reneging on his contract, or so to speak, if that makes sense. On the surface, it would appear to even seasoned attorneys that merely placing your name on your child's birth certificate and assuming paternity has created a contract whereby you can be forced to pay support and are stopped from reneging or challenging the constitutionality of your payments of support because you are not an absent parent. This is not true according to my clear reading of Wright. Yeah, I agree with him on that. If you agree with it, this is not true according to my clear reading of Wright versus Newman and clear understanding of natural law. Wright spoke on the obligation of support, not forcing support payments. So this is it also deals with contracts, and this is also dealing with natural law, because like they just said, all natural parents have an obligation to support their kids, or a legal duty, or whatever you want to call it, to support their kids, or to take care of their kids, or whatever you want to call it. It must be understood that all parents have an obligation to support their children. However, it is entirely different from being forced to pay the other parent if that parent has not done any of the two distinct acts that would fit within the definition of an absent parent. It must be absolutely understood when and why a parent is relieved from the duty of support, and when and why any court can force you to pay support according to natural law. If you have been paying attention, when and why is a simple answer, and understanding the answer is an overstanding of the Supreme Court case in Wright versus Newman. My explanation of the case and winning the grapple with any deliberate obscurity in said case and every other case applicable on this subject. Wright versus Newman does two things that creates confusion. The first thing that it does is state that Wright is stopped from reneging on the obligations and responsibilities of fatherhood. The second thing it does is state that since parents are legally obligated to support their minor children, he accepted this support obligation. The trial court's order, which compels Wright to discharge that obligation, must be affirmed. The second thing, the latter, creates the confusion because Wright versus Newman assumes, like all other courts across America today, that Mr. Wright was automatically required to pay Miss Newman child support and discharge that obligation just because he was legally obligated to do so, or just because he was legally obligated to support his minor children. A parent cannot be forced under Title 4D's mandate to do as a non-absent parent what he or she has not yet done as an absent parent, such as be forced or threatened to pay support under threat of contempt, even though the obligation may exist according to natural law, until it was proven that Mr. Wright, 1, refused custody of Miss Newman's son, and 2, failed to render her a proper support. he is not an absent parent entitled to pay support under Title 4D. I agree with that. I see what he's talking about. Thus, in hindsight, all Wright versus Newman does is establish that a contract was formed by Mr. Wright, which he assumed the obligation of fatherhood. It does not follow that the obligation comes with automatic payments to Ms. Newman, without his engaging in two distinct acts that fit the definition of an absent parent. Okay. According to the 11th Circuit and a clear understanding of Title 4D's legislative intent, from our previous reading, it is clear that families with absent parents are the only intended beneficiaries. Notice they talk about beneficiaries, y'all, as if it's some sort of trust. But anyway, intended beneficiaries of Title 4D, non-absent parents. I'm sorry, not non-absent parents. I'm sorry. All parents have a duty, obligation, and a responsibility to take care of their children. However, only while their child is in their custody and care. So what that means is, if you have kids, with a woman or man or whatever, and y'all are no longer together, when that kid goes to the father's house, let's say the kid goes to the father's house for the summer, then mom, you would be relieved from the duty to support the kid for, as long as the summer lasts, or until the kid comes back with you, and vice versa for the father. See what I'm saying? That's essentially what it means. These obligations and duties to support a child is nothing to hide or run from. It is a great honor in the terms of parenting. However, the government cannot intrude upon a parent's privacy rights. No, they cannot, because they have to prove that they have a compelling state interest. So that statute would then come up under strict scrutiny, as opposed to the best interest standard of the child. I think that's the next standard. However, the government cannot intrude upon a parent's privacy rights. Just to let y'all know, that privacy right is property. That privacy right into your upbringing and and taking care of your kids, and just how you're going to educate your kid and disciplining your kids, whatever. That right, all of those rights are property. Those rights are private property, even though they're not tangible. You can't see them, you can't touch them. They are private property, and those rights cannot be taken from you except by due process of law. If they take any of those rights from you without giving you due process of law, they have in fact violated the due process clause of your state's constitution and the federal constitution. Rights are property. All right. However, the government cannot intrude upon a parent's privacy rights and tell that parent how and when it's going to support its child and how much money a month it deems necessary for that parent to get the job done, absent any legitimate, I bet you it's coming up, government purpose to do so. The only legitimate government purpose the government has to force parents to pay child support is if that parent is an absent parent who has casted their child upon the public. The public means the government. All right. Their interest would be legitimate to intrude upon the absent parent's privacy rights, because then, in the interest of the general welfare, the government would need to decrease dependency upon the welfare rolls to ensure taxpayers were not footing the bill of the responsibilities of absent parents simply by placing absent parents on child support to ensure they themselves were taking care of their own children and would not leave the taxpayers to do so. Knowing this much, the notion that a parent with a support obligation is automatically required to pay the other parent, or can be automatically forced by the court to pay the other parent in child support without it first being proven that that parent is an absent parent, is completely unrecognizable under natural law and is a stranger to the intent of Title 4D. As such, I say again, Wright versus Newman only establishes that a contract was formed. I agree with that. At first I didn't catch on to what the author was trying to say, but I caught on to it as he explained it. As such, I say again, Wright versus Newman only establishes that a contract was formed by Mr. Wright, in which he assumed the obligations of fatherhood by signing his child's birth certificate, giving the child his last name, and acknowledging paternity. Under no circumstances can that contractual obligation include an automatic entitlement to Miss Newman receiving child support payments, in which Wright can now be forced under state police power to pay Newman. I agree, unless they prove that he's an absent parent within the meaning of Title 4D. I agree with that. Now let's take Wright versus Newman, and instead of using it in the context of one creating a contract of assuming obligations of fatherhood based on acts of signing a birth certificate and acknowledging paternity, let's use it in the context of creating a contract of paying monthly amounts in child support based on acts of voluntary sending monthly child support payments to the other parent who was depriving him or her of the custody of his or her child. Same principles, different context. According to Wright's general statements on the creation of a contract, Newman and her son relied upon Wright's promise to their detriment. The court stated if Newman had not relied upon Wright's promise, she would have not refrained from seeking support from the child's natural father, and her child would have had a source of financial support. However, because she did, promissory estoppel prevented Wright from reneging on his agreement. The same contractual argument could apply to a parent paying the other parent. I agree. If parent A pays parent B monthly amounts in support, although parent B is preventing him or her from spending overnights with his or her child, parent B could rely on those payments to his or her detriment. The argument made that if parent B had not relied upon parent A's payment of support, he or she would have known to become the provider of support. However, because parent A paid continued to, because parent A continued to pay parent B monthly amounts of support, promissory estoppel prevents parent A from stating that she and he cannot be forced to make payments because she or he is an absent parent. Now, I'm going to stop right there. I'm going to read some more, but I'm going to stop right there. Since these are contracts, he who seeks equity must do equity. Now, you can get this voided if the parent is, let's say the parent misrepresented, or in other words, fraudulently induced you into paying these child support payments under the guise that the child is biologically yours, but the parent is lying about the child actually being yours. It belongs to another man. Then yeah, you can void that. That would be that contract will be void because they misrepresented a material fact, and that fact was material. In other words, that fact played a crucial part in you deciding if whether or not you wanted to make the monthly payments or not. See what I'm saying? Let's see. So shockingly, under our current failed system, also, if you were making those payments, you can sue that parent in a court of equity and get that and recoup those funds that you gave, because that's unjust enrichment. I'm about 99% that that's unjust enrichment, and you should be able to recoup those funds back if you have been paying for I don't know how long child support or whatever you want to call it for a child that is not yours. So shockingly, under our current failed system, A father who refrains from providing support to a mother depriving him of the custody of his child to prevent the creation, of a contract could be called a deadbeat. He ain't lying. Could be called a deadbeat in society for his doing so. This is the fault of government legislation, which has been furthered by our judiciary system and heedlessly participated in by bar attorneys, that has led to a culture in our American society that has falsely believed for many generations that fathers are automatically required to pay the mother monthly amounts in child support without regard to the laws of nature or the silent creation of contracts that awaits the vigilant father who becomes aware of his unknown obligations of payment of support if deprived of custody of his child. However, even if these silent contracts await the vigilant father, one, it will be bad case law to create these precedents, and two, these alleged contracts lack the contractual capacity to form binding contracts on his and is further substantive unconscionable. Contractual capacity means that the parties are able to understand that a contract is being formed. I agree with that. In short, when a party does not understand the nature and consequences of an agreement that they have entered, the law treats the party as lacking the capacity to form a legally binding contract. Just because a person does not understand every detail of a contract does not mean that they lack competence. For example, most people that enter into a phone contract surely do not understand every detail and provision in the contract. However, they are still entering into a binding phone contract. Using this understanding as it relates to creating contracts by voluntarily paying monthly amounts in child support to a parent depriving another parent of the custody of his or her child, it could be argued that they lacked contractual capacity, that is, the understanding and a meeting of the minds, I agree with that a contract in the form of monthly payments was being formed, separate from any obligation of support. Further, it could be argued that the contract is substantively unconscionable and the result of undue influence. If parent B uses parent A's concern for their child's well-being while depriving parent A of the custody of the child, or notifies parent A that their child is in need of food, etc., and parent A, in concern for his child's well-being, pays monthly amounts in support to parent B, then any alleged contract argued by parent B created as a result of the actions of parent A can be voided as a result of undue influence. I'm guessing undue influence is some sort of equity remedy. I believe it is. Let's see. I'm gonna pause the video, y'all, and I'll be right back. All right, so let's see what they mean by undue influence. In contract law, a defense that can be used by a party to argue against the formation of a binding contract between two parties. The use of undue influence by one party over another puts the free will of one of the parties entering the contract into question, and therefore leads to the contract being unenforceable and voidable by the victim party. Okay, I see what they're saying now. So it's like you was forced to do it, as opposed to you exercising your own free will to doing it. To prove undue influence, a party must show that one party to the contract is a person with weaknesses, which makes him likely to be affected by such persuasion, and that the party exercising their persuasion is someone in special relationship with the victim that makes the victim especially susceptible to such persuasion. Okay, that's interesting. The book then left. Hold on, I got to go back to the book. All right, so we right here. All right. I think we Stopped about right here. Furthermore, this results in substantial unconscionable contracts described as a one-sided, or as an adhesive contract. Okay, as so one-sided and unreasonably favoring one of the parties. Okay. Although these contracts can be argued and potentially used to keep parents trapped in initial support orders that they were not obligated to pay in the first place, it is unlikely that the entirety of the government judiciary would create a legal precedent alleging that certain parents are now trapped in their support orders because based on contract law. Even if it attempted to do so, those contracts could easily be voided as a result of undue influence, simply because no contract can be formed using a parent's genuine concern for the financial support of his or her child as an advantage over him. I agree with that. I'm not sure what the law is on it, what the common law is on it. If parent A is influenced to believe that financial support is necessary for his child, even while relieved from the duty to support based on parent B's depriving parent A of the custody of the child through no fault of his or her own, interpreting parent A's functioning as a provider of maintenance and support, and parent A still pays support to parent B, then any contract created is void and unenforceable as a result of undue influence. So what is undue influence that caused you to enter that contract? Parent B cannot unjustly influence or cause parent A to unjustly influence. Parent B cannot unjustly influence or cause parent A to be unjustly influenced to pay parent B in concern for his child's financial support, then create a contract with parent A on that basis. This is pretty good. I believe it appropriate here to provide the answer of our first question. What and who is an absent parent? This will be the last page I read right here, y'all, because this video is getting kind of too long. An absent parent is a parent who, 1, refuses to take custody of a child, and 2, fails to render them a proper support, and 3, the nature of the absence is such as to either interrupt or to terminate the parent's functioning as a provider of maintenance and support, physical care, or guidance of the child, and the known or indefinite duration of the absence precludes counting on the parent's support or care. Okay, I think that's a good definition. So the author is essentially the author has reasonably concluded, or in other words, reasonably substantiated based on the case law that he has read, what an absent parent is. And in here, he essentially has provided you the definition of what an absent parent is. Essentially, that's what he did. We learn just by knowing the definition of an absent parent that parents are only responsible for his or her child while the child is in his or her household or custody, not while the child is in the other parent's household. Why is this so? Because a parent cannot be forced to pay the other parent monthly amounts of child support under Title 4D mandates unless that parent is an absent parent through no fault of his own. Let me see. I might have read that wrong. Let me see. Why is that so? Because a parent cannot be forced to pay the other parent monthly amounts of child support under Title 4D's mandates, unless that parent is an absent parent through no fault of his own. It still seems like I might have read that wrong, or unless the author might have put something in here wrong or something like that. But anyway, on to the next sentence. To even become an absent parent, Parent A must burden Parent B by refusing to take his or her equal share of the custody of the child and fail to give financial support to parent B, who is now burdened and has financially expanded. I'm sorry, and has to financially expand in areas where parent A is lacking. This is literally the reason why Title 4D was created, because mothers were seeking government welfare assistance because fathers were not providing any financial support to their children, leaving taxpayers to foot the bill. But today, the entire family law industry places on parents on support without even considering whether that parent is absent, and the people's ignorance have been exploited for financial gain at the emotional detriment of the child. Section 2. I think this is long enough. I'll continue with this. So we're on page 14. So I'll continue page 14 tomorrow. Again, if you want a copy of this video, not this video, but if you want a copy of this ebook, I will also make sure that a copy can be downloaded for you. So in other words, there's going to be a link in the comment section of this video, pinned in the comment section. You can click that link and you can download a copy of this ebook. The author has given me permission to give people this ebook for free. So that's what I'm doing. That'll be the end of this video. The Supreme Litigant is out. Peace.